So as normal, we've got a couple of questions which we've kind of had in through the week through different social media channels and whatnot, through the training we do and just various places we tend to pick them up. So we'll start with them, and then there's already been a couple of questions in the chat which I've removed because it had personal data in, but we'll see. It's not that we're not going to answer them. It's just as I say, I just don't want it to be up there really. So the first question I want to start off with is around this term homeless at home. So the question that came in, I've kind of paraphrased it a bit and I've removed the location, but basically, so homeless at home. What if you make a homeless application and the council have accepted a homeless duty and accepted a homeless at home request? They've sent the relevant information to the housing, and the person's currently bidding on housing register whilst waiting for a medical needs assessment. He is being supported by a national homelessness charity. So now this term homeless at home, it's something which I guess I just want to start off by saying that it's not something that's in the code of guidance or in the law itself. I think this is where the problems start, because homeless at home means different things to different people. I think I know what this question is asking about, but just to kind of make the point that it's possible to be homeless at home in terms of you might have a flat, you might have a tenancy or whatever, but it's not reasonable to continue to occupy because you can't afford the rent, or you're at risk of abuse there or something, or it's not suitable for medical needs or something like that. So you would have a home and you would be homeless there, but that's not, I don't think, what this question is really referring to. I think what this question is referring to is some councils will use that term homeless at home. So one of the councils I used to work at, they had like a homeless at home worker. And basically, this is where it starts getting interesting. When you make a homeless application, so you approach your council and ask them for help with housing, and you give them reason to believe that you might be homeless. So that triggers Section 184 immediately. They then have to assess whether you are owed a duty under Section 188 in terms of giving you interim temporary accommodation. So that's reasons to believe you might be homeless, might be eligible, might be in priority needs. But so at that point, the duty to provide temporary accommodation would kick in. But various people, for various good reasons, would say, actually, do you know what? I'd rather stay at my family. I'd rather stay at friends in the short term than move into temporary accommodation. But you want the homeless application to progress as normal. So you want the council to make inquiries and reach a decision within the on the 57th day or whatever. And most councils will be like, yeah, cool, that suits us because we don't have to find you temporary accommodation. And a good council would say, if anything changes with the relationship with your family member that you're staying with or your friend and they kick you out or something, just come straight back to us and we'll provide interim accommodation immediately as we would have done anyway. So I think that's what this question is really about. And it sounds, and again, it's kind of worth just picking apart the wording here because it's just useful to explore to kind of understand how this jargon all kicks in. So they've sent basically they've had a homeless duty accepted. Now I'm going to assume here that means the main housing duty, the main homelessness duty. So they've been in temporary accommodation probably quite some time, for a good few months, or they made a homeless application a good few months ago. The council said, yes, we've got a duty to provide you settled accommodation, and we're going to do that in this instance through the housing register. So here's your bidding number. You're going to be band B or band 2, whatever it is they're going to call it there. And then you just remain staying with family or friends whilst you bid, and you hope that you win a bid, basically. And again, kind of the question here is about while someone's waiting for a medical needs assessment. And again, sorry to kind of go over stuff. You heard me talk about this before. Medical priority under the housing register under Part 6 is a different issue from priority need under Part 7 of the Housing Act. So those, again, I'm just using those jargon. There's no way around it really. There's two parts of the Housing Act 1996 which are relevant to someone with a housing needs. One is Part 6, which is all about the housing register, and one is Part 7, which is all about homeless applications and that process. And so you may well be in priority need under Part 7, but actually you don't have any medical conditions that require a particular type of accommodation. So equally, it might be that you do, it might be you need a wheelchair accessible accommodation, something like that. But yeah, the kind of medical needs assessment for Part 6 for the housing register is a different thing from the priority need assessment that has already been done by this point, presumably. So I think that's our starting point. I've got more to say about this, but I don't want to do all the talking and hog it all. So Will and Shannon, or have you got anything to chip in at this point? Is there any other kind of sort of use of the term homeless at home that you've heard in your day-to-day, or are we kind of happy with the sort of overview I've given there?
I think just to make the point that it is really confusing. So whenever I've used it or ever heard other people use it, it's always been to describe sort of your home being unsuitable. And so I think it can become really confusing. And this is, again, it varies from area to area, doesn't it? Where every area seems to have a different term for the same thing, which makes navigating the services just quite difficult, because I read that and was almost like, oh, is it a managed move sort of situation? And then that's something completely different that other areas have probably never even heard of. Think again, then it gets sort of, when you added the layer in of the medical assessment, what part is that medical assessment under, and what are they assessing? Are they assessing just sort of the physical medical needs or mental medical needs as well? Because obviously that could play a part in, say, location. And it could be really powerful. Is it under the Care Act, or is it under occupational health? Or there's so many different avenues where lots of law, legislation, policy, just generalness all mesh, that to understand it all is quite complicated. That's my sort of take on it, I guess, which isn't very helpful. But
well, there's nothing more we can say about it, because it's all about, essentially every area's got a different Part 6 policy, and so you've basically got to read it, and you'll get different points for different conditions, potentially in different areas. So Will?
Well, I agree with your definition there, Mike. I think that it's just where you have accommodation, but it's not reasonable for you to continue to occupy, and that's from section 1753, which says you can have a home, but it's not a home legally if it's not reasonable to occupy and you are homeless. My question, or my additional part, is, I mean, this may sound silly, but in this scenario that we're describing here, that you're describing, what is the actual problem or question that the person has? In that it sounds like what they're describing is a situation which is okay in the short term, because everything seems to be moving in the right direction. They're being supported by a homeless charity. My temptation to answer that question is that it isn't right, because he or shouldn't have to be getting supported by a homeless charity. He should have been offered suitable temporary accommodation. Because I can't quite see why. I mean, unless somebody just didn't want the disruption. But if he's already in alternative accommodation, because presumably, sorry, start again. When he says he's being supported by a national homeless charity, is that just supported with casework rather than provided with temporary accommodation?
I mean, the detail's not there, but my guess is yes. I mean, potentially maybe like provide, support with getting the right medical evidence for the assessment to take place. Potentially doing the liaising with the councils,
okay.
So chasing up.
He's still in the unsuitable accommodation.
Yeah. I mean, as I say, trying to think of some examples I've worked with before. So I remember working with a lady who I use her example quite a lot in the training we do, because there was loads of stuff the council did wrong with it. But basically, eventually she was offered. She was a victim of domestic abuse. She had a kid, and so eventually the council did the right thing, accepted the application. But she said, you know what, look, I can stay with my mum short term, and I'd rather stay with my mum short term than be moved around 3 or 4 times, potentially long way away. So she was in there for about 6 months. So, Bedford's housing kind of lists are obviously faster than London's. So she was in kind of staying with a mum for 6 months, and that was okay. It wasn't a long-term solution. But it was long enough to get. She got a new build, actually. She got a new build social housing at the end of it. So I think that's kind of the situation. So I think it's almost like this person staying with maybe a family member or something, and it's kind of okay, but it's not, maybe they're out of the bedroom, maybe it's just the family member's not happy long term, which is fair enough. I think that the thing I would want to add into this is that the positive of taking this approach by saying to the council, look, I can stay where I am for the time being. I'll give you another example as well in Bedford, where a guy, he had quite significant care and support needs. He made a homeless application, and the council eventually accepted that there's a main duty to him. So he's kind of waiting for the move on housing. But he elected specifically to stay in the night shelter whilst that all happened, because in the night shelter they had a couple of meals a day. There was kind of benefits from doing that. And again, the council were happy with that, because it means they didn't have to provide TA themselves. So that's the kind of that's the positive of it. The problem with it is that basically you kind of go to the bottom of the queue in some respects. So councils, they've got this caseload of people in temporary accommodation costing them lots of money, and they kind of, they'll kind of run around there. So there's a few things to say on this. So if you're going to go through the housing register, there's a very sort of formalised waiting process. You get banding and you get priority over people who are in the same band as you if you've been on the list longer. But with the private sector discharges that councils will often use, there often, as far as I know, is not going to be any kind of formalised waiting process. There's no sort of fairness. So, again, the councils I've seen, a landlord offers a property, and it might be that the landlord's, got pretty high standards of a tenant, so they try and find someone who, on paper, is not, kind of not got lots of support needs to kind of keep the landlord on side. Whereas if the landlords, you've got landlords who are offering sort of, less quality accommodation, they'll find someone with more support needs to put in there. So they kind of have this kind of weird relationship with landlords where they need to try to give them, the right type of tenant, in their words. But if you are sitting in your own family, you're sitting in homes at home, you're staying with family, you're staying with friends long term, you're effectively not on the council's radar. They're trying to get people out of TA that they're paying money for. If you're not in that type of TA, then you're basically going to sit there until you make a fuss about it. And so essentially that's the downside. Now, having said that, almost kind of thinking aloud here, if you're in that situation where you're not on the council's radar, they're not trying to get you out as quick as possible, and often that's going to be through private rented accommodation. What it probably would mean is that you probably do have a better chance of getting social housing rather than private, because they've got these two options available to them, and they'll try and do the one. And they're in their rights to act within their interest in that sense. So it may be that if you're homeless at home, one sense you're probably going to have to wait longer to actually get your final accommodation. However, I just wonder if in some councils, the way it works out in practice is that you're actually going to be more likely to get social housing rather than private rented. So I don't know. I don't know if anyone's watching this or kind of put a question in the or comment in the chat about that, if I'm right or not, if I'm just talking nonsense. But I think that's kind of an added sort of dynamic to that process. So I think if I was homeless, I'd probably stay with a family member if I could do, if it was like a plausible, was going to last, the relationship's going to last through it. Just because I don't, as I say, it's very stressful being in temporary accommodation, even if it's decent. So I think, but there is a cost to that, as I say, that you go off the council's radar. You'd be, there's a risk you're just sitting in an in tray somewhere, and no one's really kind of bothered to move you on. So yeah, that's, I don't know. Have we got anything more to say about that one? Feels like that was a reasonable answer.
I've got one thing to say. I think from a council's point of view, it doesn't make a lot of sense to have this type of arrangement going on, because the council would have loads and loads of people sort of floating around somewhere in a grey area between being housed and not being housed. And the duty on the council, if they accept somebody's homeless, then they're under an immediate duty to provide them with suitable accommodation. And they should really, I mean, if I was advising a council, I would say to them, you shouldn't really go down this homeless at home or staying with somebody and waiting, because they're not homeless. If they've got somewhere to stay, I mean, legally you could say they're homeless because they've got no settled accommodation, but they're okay for the time being. So I would say to them, make them an offer of somewhere that you think is suitable for them, and then either say to them, we'll discharge our duty if you don't accept this. You can always come back another time, I guess, but there's no, otherwise they're in danger of being criticised, I think, for leaving people in limbo. And I think people will go along with it because, as you say, there is a hope that the longer they wait, the more social housing might come about. But I don't think there's any guarantee of that.
Am
I missing
the thing
something
is, if they make an offer, if they make a suitable offer and then they record the fact that that person's actually turned that down, and for the time being, I can't imagine any housing officer who would not take that deal. In terms of, because I think it depends how the council's structured, but sometimes you're going to have a housing options officer whose job is not only to take the application, but it's also to get them on the housing register, and it's also, in some councils, their job then to find the temporary accommodation themselves. Whereas other councils will have a housing options officer doing the front desk assessment, and then there'll be a separate team doing the temporary accommodation. So it's a little bit of a different dynamic. But if you're a housing officer, you're rushed off your feet, you've taken an application, there's a duty to provide temporary accommodation. You're a decent housing officer, you make an offer of it, say, actually, do you know what, the closest thing we've got is 50 miles away. that's how it's going to be. It's going to be B&B for the short time or something like that. If that person would say, actually, do you know what? Specifically, I can stay, I'll stay on my mum's sofa for, a couple of months. That is better than the option you're offering me. I think in that sense, everyone would win at that point. And I don't think, as long as that person genuinely hasn't been coerced into it, which does happen. That, one of my first cases I ever worked on was the council basically rang up the sister and said, if you don't house your brother, he's going to be street homeless, which is a lie because they had a duty to house him. So that was kind of clearly, it was dodgy, but a good housing officer, I think, could reach that kind of agreement. And as I say, everyone's happy. Certainly, I know housing officers who will actually say, look, if anything changes at all, like, if your relationships with your family, whatever, is going downhill, then we will, the duty will kick back in here. We will, or the offer will kick back in here. We will find you something again. But so I think that's kind of, I don't know, I guess it's going to be something which depends on the council. But yeah, I don't know. I'd need to check a textbook out to see if that term homeless at home is really explored, or if it is just like a, kind of like make your own rules up in a council sort of situation and kind of use different lingo. So yeah.
If I just say, without dragging this one on for too long, the context in which homeless at home has been considered legally in the last few years is mainly the other way around, because it's mainly involved Birmingham City Council, where they had so many people in unsuitable accommodation that they had to accept they were homeless, but then they operated a sort of unofficial homeless housing register thing where you could be homeless at home, and the longer you'd been homeless at home, the more likely they were to offer you something. And it was very difficult to measure that because it's not official. So you could be disabled but in very bad accommodation, or able-bodied but in relatively bad accommodation. And the most recent court case in the Court of Appeal, I think earlier this year, is called El-Kundi, E-L-K-U-N-D-I, where really the court was saying, if you've accepted a duty to house somebody who's homeless at home, you've got to offer them something straight away, and it's got to be suitable. And so the emphasis is on the other way around rather than encouraging people to wait. But
I think there's definitely, I think there's definitely swings and roundabouts though, Will, because I completely agree. I think as long as the council are accepting that they have a duty and they're accepting the homelessness application from the off, then I can see how it'd be beneficial for a client, particularly if you've got, say, a client with anxiety or autism or like real financial difficulties, because sometimes, there is cost to just moving and everything else. And so I think for cohort of people, it can definitely be useful. But like you say, as long as they're not avoiding sort of the duty that they do have. And I think that's where it becomes like complicated and grey.
And there's quite a lot of faith involved to think that the council are actually maintaining that arrangement and saying, well, we know that you're staying somewhere and we're keeping an eye on this. Because in reality, I think that a lot of the time the person just sort of goes into the sort of filing cabinet and it's nothing, they can wait for ages.
So I think it's probably I think it's good to kind of just have these discussions and explore it. I think it's also good if we can try and sort of summarize what we've said at least. So it seems to me like, add into stuff if you think I'm wrong about this. So it seems to me if you've got a council that's going to follow the law, they are going to offer suitable temporary accommodation from the get-go. There's going to be no messing around with them. There's going to be no sort of chasing around. You don't, or you've got a really good solicitor on your side, from the off doing the same thing. Then yeah, take the temporary accommodation because it's likely it's going to result in you getting housed more quickly. However, in the real world, the pragmatic approach of having a council that is probably going to break the law pretty soon anyway, even if they even if you do reach this sort of agreement, is to try to give the housing options officer some some leverage or whatever, or some just make it a bit easier for them to kind of go down this route. And as I say, I've certainly seen situations where it's in everyone's interest to do it that way. Big picture, it's probably not, because big picture, you lose the pressure on the council's TA in the sense of it stops driving the kind of the improvements, as I guess you'd see in Birmingham, where you kind of mentioned, Will. So is that a fair kind of summary of what we've said? Yeah. Okay. Cool. I've just seen some questions on the live chat. I'm going to try to get my head around them. when I can. There's quite a long one there, so I might just try and read that when we're doing the next one. But the next question we had planned is it's one that actually came off the back of last week's one, so it's kind of a follow-up question that came off the last Q&A. So if you're single under 35 and homeless and they refuse to give you temporary accommodation, but they give a duty to rehouse or prevent your homelessness, and you're only entitled to shared accommodation LHA rates as part of their PHP, what happens if you can't find a tenancy or a shared room or whatever, a shared accommodation during the 56-day prevention period? Now, as with all questions like this, there's a lot to unpick, and it kind of takes a little bit of time to work out what exactly the person means, because they're not going to be up to speed with all the different jargon that's kind of going on around them. But the way I would interpret this question would be is that you've got someone, they're single, they're under 35, so they're only eligible for the shared accommodation rate if they're in the private rented sector, and they've approached the council for help. It seems from the question to infer that they've approached the council for help before they've actually become homeless. So it's in the prevention duty. So if you're likely to be homeless in the next 56 days, you can make a homeless application to the council now. You don't have to wait to actually lose your accommodation. And then this prevention duty kicks in. And I hate the way the PHP and relief duty and prevention duty all works together. I'm pretty sure the council should be doing a PHP, a personalised housing plan, pretty much immediately in that prevention duty to see if they can act to avoid you becoming homeless in the first place. Obviously, in this case, that doesn't appear to have been successful. If it's not successful, you then become homeless. The relief duty kicks in, what's called the relief duty kicks in. And if you are not in priority needs, if there's no reason to think you might be in priority needs, the council don't have to provide Section 188 accommodation for you during that relief period. So ultimately, and this is kind of the ultimate answer to this question, is if you haven't been able to find something in the 56-day relief period, then often councils, all they'll be doing is giving you a list of landlords, or telling you to go and look on shop notice boards or whatever tends to be the standard advice. It's entirely possible that you won't be able to find anything, and at that point, they don't have to find you. This is where Will might disagree with me. They don't have to find you a roof over there. They have to take reasonable steps to try to find you something. But it's not, as far as I know, there's no absolute duty to get you under a roof. And at this, for somebody who's not in priority needs, ironically, or that's not the right word, but they'll actually be looking for support accommodation often during this relief period, because it's actually the most quickly available accommodation. Even though in theory, if you're not in priority need, you probably won't need the support, but that's the kind of the perversity of the sector. So you have lots of people in, kind of get put in. We had someone this week, actually, me and Shannon had someone a question about someone who literally, self-employed, didn't have any support issues at all, approached the council and they stuck them into a kind of a supported accommodation place where the rent was ridiculous. And then they got into loads of arrears, and then then they're in a bit of a situation. So that's the lie of the land. But Will, what have I missed there? So I know you kind of think a lot more of the relief duty than I think of it.
Well,
but what
yeah,
does it actually have to do with someone who's not in priority needs?
Well, yeah, I'm thinking the nature of the relief duty is to provide accommodation for 56 days, whilst they take steps to try and help you find accommodation for a longer period. Does that sound right?
I'd say that was what I thought it was supposed to be when the HRA bill came in. But then, as far as I know, there's no duty to provide any sort of accommodation. You don't have to. You can try and help someone into it, but there's nothing they have to do in that 56-day relief period if you're not in priority need. If there's no reason to think you might be in priority needs, as I say, I think that was why everyone was kind of thinking, oh, this HRA might be really good. And then I think they worked out how much it cost, and they took that bit out of it again. So as far as I know, if you're not in priority need, they don't have to, they can, as I say, they can say, well, look, there's a night shelter down the road, or we can refer you to a refuge, or that's probably a good example that gets confusing with domestic abuse, but they can find something for you in that period, but they don't have to. They have to try to, but if there is nothing, and if you're unsuccessful in that relief period, then my understanding is the relief period can end after. It doesn't have to, but it can really end after 56 days. And there is potentially a situation where the council has not got you housed. They might have given you some good advice, but if there is no housing available, then I think you're potentially stuck. Now, again, this might be if I've got that wrong, or if we're not sure about the detail of that, then it might be something we come back to next time and we do a bit of research on it. But that's my understanding of the way the relief duty works, is that there is no roof over your head duty. There's a duty to do a PHP, there's a duty to take reasonable steps, which is a case of offering you quite a lot of support to find something, but it's not the same thing as actually providing it itself. But yeah, correct me if I'm wrong.
Well, maybe I'm just having a sort of mental block, but my understanding was that the relief duty is a duty to take reason. I'm just looking at Westminster City Council's website to refresh myself, and their outline of the relief duty is that we must take reasonable steps to help you secure suitable accommodation, and that lasts for 56 days. So if we go back to this scenario in the question, that they've refused, I mean, the question is, what have they actually done under the relief duty? They've refused to give temporary accommodation, and then at the end of that, presumably they're saying, well, that's the end of the 56 days.
Are they not still in prevention duty, or am I misreading the question? Because
Yeah,
I think they're in prevention duty still.
So the question would suggest they're still in prevention duty, but I think we kind of jumped ahead and said, you know, what happens if they actually become homeless at the end of that, and the relief duty kicks in. So my, again, I you know what I think about the relief duty. Well, it's something that in certainly Bedford, that it never really became that relevant. Really, you know, the PHP was relevant, which was just a template often, and you know, the reasonable steps to secure accommodation is not the same thing as, you know, if you compare that with Section 108, which is they must secure that accommodation is available for that person's occupation. It's a lesser duty. So certainly in my experiences, people who are not in priority needs, you know, that the reasonable steps might be, here's a list of local supported accommodation. We will refer you to those supported accommodation projects. You then need to attend the interview, and if you're successful, you then have to wait while still being homeless, basically. Again, if I've got this one wrong, it's a big one. But yes, that's how I thought it worked out. I mean, Will, there's just an easy question coming on the chat. Whilst you're looking into it, I'll just answer a question there about,
okay, cool. I'll keep
coming there about why council's doing affordability assessments. So in the standard kind of council will have a pack of forms that you've got to fill in when you make any sort of homeless application, really, in terms of housing register or homeless application. And it will kind of essentially be an income and expenditure form, is essentially what it is. So it will kind of have a column which is all the kind of income you might be getting. So whether it's, you know, it might be a benefit you're receiving, or it might be employment, those sorts of things. What's your monthly salary, all those kind of different things that they take into account. And then on the other column will be your outgoings. And often I hate doing these with people because, you know, they don't know how much they're going to be spending on the next heat and bill in the next project, you know, place they live. And there's going to be sums like, you know, who actually knows how much they pay, you know, how much they spend on food every week. It's not something that, you know, unless you're really kind of diligent with your budgeting, you're not actually going to know. But that's the kind of thing you're expected to do. So quite often people just kind of make it up. So I'll kind of use the AHAS, there's research done by AHAS, which is Association of Housing Advice Services, I think. And I'll kind of use them as starting points when I'm working with someone, say, look, you know, this AHAS figure says £28 a week on food. Let's start with that and just see if you think it's less or more than that. But, you know, often, sorry, I'm not actually answering the question here, but affordability assessments can also come and sting you, because I worked with someone who basically was going to be evicted, and she had to kind of, you know, demonstrate to the judge that she could repay some of the arrears. And so they went in, the housing officer basically made a ridiculous you know, kind of affordability assessment, said, oh yeah, no, she can afford to pay like £400 back every month. And it was totally unrealistic from the start. And although the mum did do her best to pay what she could, there's no way she's going to pay that much. And then that affordability assessment was then used against her when she became homeless. They're saying, oh, you know, you said you could afford the £400 a month to spare. Well, you know, why didn't you put it on the rent or whatever? It was stupid. So those are some of the kind of things that kind of happen with the affordability assessment. But the actual, you know, to answer the question, sorry, Omar, but the actual question is, well, part of the question is, any accommodation they find for you has to be suitable, and part of that means it has to be affordable for you to, you know, to be able to live there. And so if they, you know, if you're, you know, if you've got court fines and child maintenance payments, things that you can't avoid paying, in addition to your, you know, food and kind of gas and electric and everything, then they need to be very, very careful about what type of property they work in. They put you in. So I worked with a family. Once mum was subject to the benefit cap, and the council put her into private rented accommodation, which from day one was never affordable. So she came to us after that kind of happened, and I went back to the council saying, let's have a look at, let's do a subject access request, and let's have a look at the income and expenditure form we did with this person, because from that you should have seen that there was no way that she could afford this top up in this private rented place, because it was, I don't know, like £150 a month or something like that. There's just no way that she could find that money. And so actually what the council then did was they re-accepted the main homelessness due to kind of house them somewhere else, I think, or the DHP as well. So that's kind of, why the council will be looking at those figures. Sometimes it's a bit of a, kind of a false kind of exercise and just kind of doing what you've got to do. But other times it will be useful to kind of inform what type of accommodation is going to be available for you and suitable for you. So hopefully I've padded enough there, Will. Have you found anything else?
Yeah, I have actually. I've sort of untangled the knot in my mind there. But tell me if you think I've got this wrong. That the relief duty is the duty to take reasonable steps to assist the person in securing suitable accommodations available for 6 months. And there isn't an interim duty to provide temporary accommodation like there is with Section 188, but there is still a duty to come up with a reasonable plan. Now, if somebody goes to the council and says, it gives them information to the effect that they accept that a relief duty is owed and that they're still sleeping rough after, say, 1 day, 2 days, 3 days, there comes a point to say, well, what kind of plan is this? Because it doesn't seem that they've secured anything. And so you could say they haven't discharged the duty because they haven't come up with any plan because the person's still homeless. And the solution to that is to request a review of the personal housing plan or the steps to be taken by the council under the personal housing plan. Now, this is where it gets a little bit muggy, because if you've got a right to a Section 202 review, the time limit for the council to complete the Section 202 review is, by coincidence, 8 weeks, 56 days. So in theory, if you haven't got accommodation and you say, I'd like a review of this, please, and they say, okay, then we'll let you know in 56 days, during which time they could then say, well, the 56 days is up now. But I think there's a case for saying, and maybe somebody who understands this and is their mind sharper than mine at the moment can get around that, because I think that that's totally unsatisfactory, isn't it? Because the problem with this, before the Homelessness Reduction Act came in, the problem with duties to anyone who wasn't in priority need was that they were just a sort of joke, really, because they would just say, here's a list of landlords, and it may be sort of years out of date, off you go. We've given you advice and assistance, and people wouldn't interfere with that. So the new act then said you have to do an assessment of the person's housing needs, and I think you've really got to show how you've met them. But then there's been a sort of grey area of when you can go for a judicial review and when you can go for a homelessness review. A judicial review has the advantage of having immediate results, whereas a homelessness review kicks it off into the long grass for 8 weeks. So I have to look back into that, but that doesn't get as much. So the question that was being asked there, so I suppose the question, just to go back, if you can't find accommodation during the 57-day prevention period, then presumably do you become, you're not homeless, are you? Because you're still in a situation where you're facing homelessness.
Yeah, so within prevention duty, at that point it's kind of, and this is where it gets more complicated. So as far as I understand it, and this is something I got wrong a few weeks ago, but there's essentially no penalty if you don't comply with the PHP during the prevention duty, but there is if you don't comply with the PHP and the relief duty. So if they make what they say is a suitable offer of accommodation in the prevention duty, again, treat this with a pinch of salt, because I think I'm getting my head around this right, is that they would, they would just proceed into the relief duty, and then they kind of, they take it from there. Whereas if you turn down that reasonable offer, it's either a final accommodation offer or a final Part 6 offer, I think it's called, If you turn that down in the relief period, then they can essentially just end all duty, which is the bit I hadn't taken into account. So yeah, it just shows how kind of convoluted this all gets. Yeah, I'm still not a fan of the HRA, but basically, yeah, going back to the question, and I think actually that I can give a bit more detail about an answer as well. But essentially, if you're in that bracket, you're in that bracket of you're single, you're not in priority need, let's assume. And I guess one of the things that would be worth saying is that the threshold of vulnerability within priority need, so the threshold of the kinds of issues you'd need to face in order to be in priority need through vulnerability is actually nowhere near as high as the council will say it is. So essentially, there's just got to be something that differentiates you from an ordinary, healthy and robust person, which is the words the law uses. That would essentially put you at risk of more harm. So it might be you've got a health issue that be exacerbated by homelessness, that would then lead to a risk of harm. That's all it takes to be in priority need. So as I say, councils, they tend to be very, very, way overboard with the kind of that threshold in itself. But if you genuinely are not in priority needs, my answer is essentially the council doesn't, other than kind of doing a PHP and kind of lays out, here's some different hostels, some support accommodation or whatever, they could get to that day 57 and say, right, well, relief duty's ended. There's nothing else we need to do now. You're still homeless, but that's the kind of that's all. We've done our bit by coming up with this PHP. The code of guidance does say that they don't have to end the relief duty after 56 days. They can extend it. And it's important that they use their discretion there. But as far as I say, that's I think the end of it. I'm just going to go back to the question where it originally was, just because I know that there was a really helpful comment on there from someone else, which essentially kind of gave a lot more, kind of some more detail on it. Yeah, I found it, but I'll come back to it in a minute. Okay, so there's been a question on the live chat here, which I'm going to try to unpick a little bit because it's quite a long one. Okay, the part of the message has been retracted, which makes it quite tricky. So we've got someone who's got one child and is currently pregnant. She submits a homelessness application, and her application was refused because she is working. Let me just read that let me just read. So then there's another one. The relevant question is it crucial for a heavily pregnant mother with one child must be working before submitting homelessness application? And then it goes on to say she's not working. Okay, so let's just try and unpick this question. I think what it's saying is she's approached the council, she's pregnant, she's got one child, she's homeless, and they're saying that because she's not working, she can't get any help. Now, I can only assume from that there's some issue around eligibility of some sort. So there's some kind of issue around recourse to public fund or something, which would mean that they're essentially saying, I don't know, Will, can you make sense of this question? I can't, just to state the obvious, whether you're working or not does not affect any, the way the kind of the Housing Act works, unless it is, I guess, with some kind of nook and cranny of eligibility status. So whether you're homeless doesn't matter if you're working or not. Whether you're in priority need doesn't matter if you're working or not. It's entirely possible to be in priority need and be working. Yeah. So I don't know, Will, what do you, have you
my initial thought was that anybody telling a homeless applicant they have to be working in order to apply is obviously giving unlawful advice, and that should be challenged, because whether or not you're working doesn't come into it. This is casting my mind back. In terms of eligibility, I don't think there is, immigration is so complicated, somebody will probably correct me, but I don't think there's any criteria at the moment that mean that you would have recourse to public funds or eligibility for housing if you were working. But there used to be, under the European free movement stuff, that if you were, I think, what was the word, not a job seeker, you were either seeking work or exercising treaty rights to work, then you were okay. But if you lost your job, you were in danger of then losing all the other entitlements as well, unless you could show you were genuinely looking. But my understanding is that's all historical now. So
with Brexit,
I can't.
I think I'm with you, because I think also, Will, back then you would get, even if you weren't, you would essentially, if you're working, say 16 hours a week or something in that bracket, so say you're a Polish national working 16 hours a week, you'd also be eligible immediately as soon as you start working off to get housing benefit, if I remember correctly.
Yeah. So I mean, case law around that.
Yeah.
But
I don't know. Yeah, so I don't know. Yeah, I don't know if the person's still watching, whether they can kind of clarify that question a bit.
The only other thing I can think of is that, again, and we see this quite a bit, don't we? But they've done a homelessness application form, and it's not actually a homelessness application in the legal sense, but they might have, say, done it and applied for the housing register. And if their housing allocations policy say to be nominated for this sort of housing
yeah, that's
association, you
true.
need to be working. That's the only thing, because we were having this conversation earlier, weren't we, where councils use the same words and they call it homelessness application, where actually they might be going an application for homelessness or whatever it might be. So that's the only thing I can think of.
Yeah,
You might be right, because it could also kick. Yeah, you may well be right there, Shannon, because it could also kick them at that point with local connection. So it might be that the council saying, well, you don't have local connection, you know, because you haven't lived there and because you don't have a job here. So
Yeah.
again, Part 6 will have it has a much stricter version of the Part 7 local connection criteria. Often within Part 7, you know, it's not just a case of having a job. You need to have a job and have done the job for X amount of hours a week for a year, or, you know, I guess in London it's probably even higher than that. Whereas you know, in Part 7 it never really defines that. It just says if you have a job in an area, that's the end of it. You have a local connection. So that, yeah, you might be right there, Shannon. So hopefully that helps. I'm not sure if it does or not, but yeah,
I think the bottom line is it shouldn't be an obstacle to a homelessness application. And
yeah,
if somebody was denied an possibility of going on a housing register, they might want to look into whether it's a disability, it's discriminatory, because if, say, you were pregnant and you weren't working, that would be discriminatory because it tends to be women who are pregnant, and that's a characteristic. So you're being penalised because of that. But I think there's not much point going into it in more detail without more information on that, is there?
yeah. Okay, cool. Couple more questions coming in there. So, what should a person expect at an assessment who is sofa surfing? So again, I guess the word assessment here is applying to the Part 7 assessment. So different councils again use different terminology. So councils for Bedford, where I do my work, is they call it a homelessness interview, but it's just an assessment. That's all it really is. So you make a homeless application. Ideally, you always want to make it via email. Don't ever, I never advise anyone to go down to the council or ring them up, whatever. Always do it in an email. Say, I want housing. Can you help me out? I'm homeless. That triggers the application. But at some point, usually, hopefully very soon, they're going to want to have a conversation with you. Either some councils still do it just on the phone, so you don't even get a face-to-face assessment now, whereas other councils are, after COVID, kind of returning to face-to-face assessments. Often it'll be like an hour or so, and often it'll be incredibly intimidating. So I've got some stuff to say, and I'm pretty sure Shannon will have some stuff to say here. So often it'll be in an open plan customer service centre where you are being grilled about lots of things in public, basically, all sorts of random stuff about your health, about, kind of potentially abuse you're suffering, and you're expected to give, kind of comprehensive answers in that setting. Now, this is a bugbear of mine. If you know me, I love a bit of data protection law. And services have to be data protection compliant by design and default, which means they need to be, it needs to be possible to keep your stuff confidential in any kind of service. So this is something in Bedford, just to give an example, we basically challenged the use of open plan customer service centres and said, this is not lawful. You need to make sure these interviews are done in a private interview room. So, and they agreed to do that before COVID. I think after COVID, they've got a bit sloppy with it again. But that's the first thing. So you can ask, the person, you can ask for a private interview space if you're getting a face-to-face. If it's over the phone, then if personally speaking on, I would record that conversation. That's just me personally. I'm not saying people should do that. It is legal to covertly record stuff. But I would want a recording of that conversation, because you're not signing anything. You're not seeing what notes they've written. It's just it's kind of difficult to make sure they're actually done the right job there. But if you're then in a private interview space, again, you guys could chip in a bit, but certainly, it's probably not going to be a particularly nice environment, but it will be private at least, but if you get that far. And you can, if you've got a good housing officer, it's okay. Guess what I'd say, having witnessed a lot of them. If you've got a bad housing officer, it is very, very unpleasant, very, very stressful indeed. I've seen housing officers almost kind of twist the knife with people if they, they say they've got anxiety. They seem to make it as kind of anxiety causing as possible. They kind of make it as difficult as possible for that person. So you can, things like, you can always go and take 5 minutes, have a breather if it's getting a bit too much. If you're going to go to a face-to-face, take a friend, take a professional with you, and take lots of notes, or even just make it look like you're taking lots of notes. I just kind of doodle, but people think I'm taking notes, because that just shows the officer that you're kind of taking notice of what they're saying, and you're getting a written record of it. I've got more to say, but yeah, you guys feel free to chip in.
Yeah, so I mean, there's a second part to that as well, where they've sort of said, does PIP help with the application? And I guess I'm going to assume you sort of mean assessment part, because ideally you want to take sort of as much evidence that you've got to that assessment, because a lot of the questions will be quite intrusive in a way. So if you've got documents where you can sort of just hand them over, that's almost to your benefit. I mean, PIP could help around sort of certain aspects if you have sort of the assessment letter from PIP explaining your needs, whether that's to do with how many bedrooms or sort of location or anxieties or physical mobility issues. You might not sort of be able to do stairs or whatever it might be. But I would say Mike's tips of taking someone with you, making notes and checking what they've written down, just so you've got it clear in your head, because you're already in an overwhelming and stressful situation. So just be really kind to yourself and make that as easy as possible. And then, yeah, hopefully you'll get the best out of it.
Yeah, I mean, I know I don't want to scare people, but sometimes it is like going into a lion's den. Some of these housing officers are nasty people. In my experience, I've met a few people I consider to be genuine sadists almost, and they seem to enjoy it. They seem to enjoy just turning the screw on people. So, a few little things around that. Again, little tips here. So, again, these might seem like kind of really niche ones, but if you're a victim of domestic abuse, you can ask for an officer of the same gender as you. So I remember working with I went in with a lady, she was fleeing domestic abuse, and the male officer, he wasn't horrible, but he just basically said, well, you haven't fled yet, so you're not homeless. And I was like, no, that's nonsense. You're already homeless if you're subject to domestic abuse. And he just wouldn't back down. And so she ended up kind of crying and left. And the way we dealt with that was we went back and said, look, can we have a female officer, please? And then we raised the other issues as well. And the female officer was actually totally decent, and kind of it went really well from that point. So you can do things like that in terms of, it might kind of help, help get a better outcome. There's I'm sure I think some other stuff that might help at that point as well. So in terms of the PIP as well, just to kind of say, just because you're on PIP doesn't mean you're automatically in priority need, but you almost certainly are. It's difficult to imagine a disability which is not going to be made worse by being homeless, and is not going to be more than trivial is the kind of threshold. So it seems to me, although it's not an automatic thing, there was a case back in 2017 where there was a time when the judge said, yeah, if you've got disability, then you're automatically vulnerable. But then that kind of changed again. But you just need to kind of do the legwork of saying, look, these are my issues, these are my disabilities. These are, might be that you also things like not having support network. It might be you've rough slept for a time before. These are the issues that I've got, might be you're a veteran, whatever. And this is how homelessness is going to affect these issues. So if you've got a medical issue, a doctor's letter saying, this guy's got arthritis, and if he becomes homeless, it's obviously going to get worse. That's a very helpful letter. So you can kind of, I guess it's just kind of worth covering a bit of vulnerability with that as well. Anything else anyone wants to say about that question? It's good questions.
I would just like to add, I mean, without wishing to be negative and upset people who might be waiting for assessment meetings, I'm very cynical, and my advice would be, what to expect as an assessment meeting is probably to get messed around or to get people trying to catch you out. Or look for an excuse not to help you, because even though I agree with you that there are some very unpleasant housing officers out there, there's also, it has to be said, lots of good ones who do the best they can in difficult circumstances. But the dynamic of the system is negative if you think about it, because in order to I've always thought it like a hurdle race. in order to get from being homeless to being housed, you have to jump over these hurdles. You have to be eligible, homeless, unintentionally homeless, priority need, local connection. And the purpose of the assessment is in some ways to find a way to get that hurdle high enough that you can't get over it. And if you look at, and by the way, am I allowed to mention the names of the people putting comments in? Because
I think
Because
if
other
you
people
can
can see
avoid it,
them,
just
can't
use
they?
initials.
Oh,
I mean, I
okay.
don't. I think
Because
they're on there, but yeah.
Yeah, the person, well, it isn't, I suspect that isn't their real name, but the next person that has put the question in has described a series of pieces of rather bad advice that they were given. And it sounds like that's the sort of thing you might get told at an assessment meeting is, oh, it doesn't sound like you've got priority need and therefore you should look for somewhere in the private sector, have you thought of that? And so I'd say, expect to be messed around, but don't give up, because if you are messed around, that is what's happening, and it needn't necessarily be that it's because you're not entitled to anything. And remember, they have to, I mean, it will normally follow inevitably, but they have to put their decision in writing. They have to issue a Section 184 notice and draw up a personal housing plan. So it might be best just to answer the questions as openly as you can and cooperate as much as you can, and don't let them wind you up, because there's an element to that as well. People sort of try and think, I wonder if I can get this person to lose their temper and go away, or get kicked out. Just answer all the questions and then say, well, okay, I'll just wait till I get my decision from you if they make negative comments, because you can then challenge that. Sorry if that's a bit negative, but if you do that, if you follow that, you only get nice surprises.
I mean, I'm sure. I mean, I used to work in a team where the team leader would basically tell the staff, use whichever test gets rid of them first. So if they don't local connection, use that. Just make the evidence up. That's the kind of stuff he'd say. So yeah, I think we need to be. I think it's best that we're just honest about the way that the system works. If you get a good housing officer, it will be pleasant. Plenty of people have a really good experience of it, or not good experience, but you know what I mean. Like it's kind of the housing officer's sympathetic, they're fair, they take time to explain things. They're thorough, and they kind of give you lots of opportunity to kind of give more information. Those are good housing officers. But if you get a bad one, you're in for a rough ride. So a really interesting statistic from the work we did at Just Us. So when you look at the two groups of people that have made homeless applications, so people who applied on their own, went to a council on their own without an advocate, versus people who went to a council with a knowledgeable advocate, the actual stats were 86% of the time people were told there was no duty to house them when there actually was if they went on their own. Whereas if they went with a knowledgeable advocate, it was only 12%. So if you can take a decent professional down with you, might be just anyone who's kind of used to kind of this sort of process. So it might be that they've got no knowledge of housing law, but it might be they know about HR law or something like that. So you kind of go in there. It's lots of the principles still apply, and just take lots of. And as Will says, it's about not giving up. And that's a really horrible thing to say, because what it means is if you're the most vulnerable people, the ones with the most difficulties and the most obstacles in their general life, they're the ones that kind of are going to give up first, because they've got so many other things to worry about. And that's kind of what gatekeeping does, is it keeps people, the most vulnerable people, the people that this is supposed to be there for, actually, they're the easiest ones to get rid of. And it's the Karens of the world, sorry for any Karens watching, the Karens of the world who will stamp their feet and ask to speak to a manager who actually get the best service. And they're the ones who go to the MP and the councillors and kind of stamp their feet around, and they do get a better service. So how many for time? I'll just tackle this one here. That's kind of the sequence of, so family with children, I'll just kind of paraphrase. Made homeless from another family members because of overcrowding. And essentially the council's just stalling. They're not doing anything. They're not responding to any emails. By the look of it, they're not kind of doing what they said they do when they said they do it. And there's a few issues here, and Will's kind of covered them in terms of getting the decision in writing and stuff like that is really important. But if you're not getting any kind of response at all, which is unfortunately the pretty standard thing these days, again, get your Karen on, get your copying in councillors, copying in MPs, complaining to the chief executive of the council, all of those things. My advice would be just be as quick as you can to do that. Don't wait around. Don't wait 2 months to think, I'm going to complain to the chief exec now. The day something isn't done, just go in hard, legitimately, but go in, go and do something which is like, shows them that you are not going to go away, and you're not going to be patient with housing officers who are very busy. I said it elsewhere. I sympathise with housing officers. They've got a very, very difficult job indeed. But I always sympathise with homeless people more, because that housing officer will probably have a roof over their head, and they will probably have a bed to sleep in that night. And however difficult it is, they can always quit. Whereas if you're homeless, you can't quit. There's no way out of it. So I think don't be afraid to act within your rights, and kind of I think a lot of people kind of apologise for kind of expecting to be treated like citizens of this country, and I think that's something you just need to be kind of real kind of quick to actually act in your own interest and do the thing which is best for you. So yeah, I think so. And again, just kind of general stuff. Loads of questions people ask me. The first thing I say is make a subject access request. That gives you all the records that they've got about you within 30 days. And if they don't give it to you on the 30th day, complain to the chief exec and say, I made a subject access request and I haven't got the answers yet. And then also, be very, as I say, go through the formal complaints process. The first bit of advice I ever got from the LGO, which is when I started doing casework, the guy on the phone I spoke to was really nice. He just said, look, don't worry about the formal complaints process. Just copy in the chief exec to the first stage complaint, or address the first stage complaint to the chief exec. That, in his experience, is the best way to get things done. And in my experience, that he was absolutely right about that. So yeah, don't be slow to kind of invoke those things. Otherwise, you'll just get left on a pile of papers somewhere.
Just a quick question, because on the comment it says that they've been told that they're owed prevention duty. Now, it's been a long day for me, but would they not be in the relief duty because they are currently homeless because it's unsuitable to occupy? In which case, would it be worth them almost making a fresh homelessness application on the basis of new information that their type of homelessness has changed? Or and then triggering that sort of relief duty rather than being stuck in this prevention duty that seems to be going nowhere?
Yeah, I think you might be absolutely right there, Shannon. I'm just reading the details. So yeah, I guess so they're now living with the uncle. Now again, this is kind of depending on if the uncle's got a 14-bed mansion and he's perfectly happy for you to remain there, then you're probably not homeless, but that is unlikely to be the case. It's likely you're going to be sleeping in the sofa on the lounge floor or whatever with your kids. So clearly, that is not accommodation which is reasonable to continue to occupy. You are already homeless. You, at this point, we're probably in the ballpark here of compensation from an LGO if you stick with the process and go, it's going to take a year and a half to get an outcome. But this is the sort of thing the LGO would be very quick to say, well, actually, the council's got reasons to believe you are homeless now. It's not the reason to believe you might be homeless or might be threatened with homelessness. You are now homeless. So that they should have kind of looked at Section 1. They should have offered Section 188 temporary accommodation already. And if they haven't, then you don't have to go to court to get compensation for that. You can go through the LGO through the complaints process. I probably need to do a specific video about how that all works, kind of on the normal channel. So yeah. Again, I'm hoping some of that is helpful to that for that question. But yeah, subject access request, complain, and either trigger a fresh homeless application, Shannon says, or in theory, if you just made the complaint to say, I'm already homeless, why am I not being dealt with as a homeless person? Under the relief duty rather than prevention duty, that might well do the trick, hopefully. Yeah. So I'm just checking the questions we had before, kind of in advance. And there's just one more question I want to cover, if that's so. If you've got time, guys, yeah? You want another sort of 5 minutes?
Yep.
So this is a question, I can't remember where it came from this time, but I think I sent it as a message or something. But so my landlord is selling the house. I couldn't find suitable private accommodation in the same area. If I move out of the borough, what will happen to my housing application? So that's question one. I feel trapped, about to become homeless, but council says I'm intentionally homeless as I'm moving out. So essentially what they're talking about is leaving the accommodation before the eviction's actually done properly, because what seems to be the case is that the landlord is refusing this to give a Section 21 notice. And I think, if I remember correctly from the way the question came in, essentially what the situation is that the owners of the property, so the landlords, I think one of them's got a terminal illness and has basically said to the tenants, look, you know, my husband's dying or something, and you know, you guys need to leave. And that is not in any way a valid, you know, it's really sad that that's the case, but that's not a valid eviction notice. And yes, if you were to leave that property before they serve a valid eviction notice and it runs its course, you may well become, you know, you may well be classed as intentionally homeless. And not only would you be intentionally homeless under a homeless application under Part 7, but potentially the housing register, so the Part 6 policy will have something in there about knowingly worsening your conditions, which is essentially the same thing as being intentionally homeless, same idea. And actually that could really stuff you up, you know, so, you know, you really don't want to be in that situation. So again, as difficult as it is to kind of to deal with the landlord in that situation, if that is the situation, I think I've just made that up. But you know, one thing you can do is just say, you know, go to the council and say, look, they're refusing to give a Section 21 and they keep telling me to leave. The housing officer can contact the landlord and say, oi, you know, you need to follow the law, you need to stop harassing your tenants. And most landlords would listen to that, in my experience. You know, there's actually a lot of good stuff that housing officers can do with that. They can take action against dodgy landlords, reading the right act and stuff like that. So that's something that might come in. But so that's kind of the second part of the question answered. So, you know, you don't ever leave accommodation that, you know, you can remain illegally, unless it's unsafe or something. But the other question is, you know, if someone was to move borough, so they're you know, again, it's worth kind of looking at the workings out here. So they're in accommodation, but they're not being actually given any eviction notice, and yet they are bidding on the housing register, or they've made a housing register application. Now, in most councils I'm aware of, if you are adequately housed or seen to be adequately housed, you can't get on the housing register anyway. There's just, you know, there's just no banding for it. So unless you've got some kind of housing need, that, yeah, your housing application, your Part 6 housing register application will be rejected anyway. But let's say that, you know, you're in overcrowded accommodation, so you know, there is some kind of housing need, you are on the housing register, and you were to move boroughs. Essentially, you know, if you move to a property in a different borough which was then suitable for you, then again your housing register application would probably close because you're now adequately housed. But if you moved from one overcrowded property to another, you would need to update, again, it would depend on the area, but you would need to update the housing register of that change. But I don't necessarily think that you would lose, I don't think you'd be deregistered just for moving out of area on that basis alone, unless there was some sort of local connection criteria around it. I don't know. So, you know, if we're talking about someone who is at risk of homelessness, so let's say, you know, either you are overcrowded or, you know, the landlord does actually serve a valid notice at some point, then you ought to be making a homeless application and kind of getting that, you know, going down the Part 7 route, because, well, for various reasons, basically it's often a kind of an easier way to get onto the housing register anyway with a higher banding. But it's something that, yeah, might come into play. But as I say, I don't know of any, I can't think of a housing allocation scheme. So that's the policy of housing register, where you would automatically be kicked off the register because you're no longer in the area. Unless, as I say, unless you're now adequately housed somewhere. But that wouldn't matter which area you're in. It might be you're in the same area, but you're adequately housed, so it wouldn't make any difference. You know, you would be adequately housed, so they'd take you off the register if they knew about it, I would have thought. So yeah, I don't know.
I think you can. I'm sorry to contradict you, but I think depends on each borough's allocation policy document. But I had a case involving either Ealing or Hounslow, one of the West London boroughs, where the person had been on the housing register and the council themselves put them in temporary accommodation in a different borough and then kicked them off the housing register. And I tried to appeal it, but I couldn't, because the requirement was you have to have been living in the borough for the last 5 years. And if you then stop living in the borough, maybe you're going to point out why.
No.
So, further, but,
no. So, okay. So I worked in the case with Central Beds, where their policies, their Part 6 policy said you need to live there for the last 3 years continuously. She lost her tenancy. She moved in with a daughter in Bedford, was there for a month or so, made a housing register application to Central Beds, and they said, no, you're not being here for 3 years. Now I appealed that and said that's ridiculous. You know, but in the situation you said, I'm sure that, doesn't surprise me that happens in London, but surely once that, so if they've been accepted as homeless, they're in temporary accommodation and they've been placed out of area, once the homeless application runs its course and they make a final decision, wouldn't that essentially get them back onto the housing register because the council owes them a Section 193 duty? But so they would, so they might no longer have local connection for the purpose of the housing register, and they might lose their registration if they're in limbo in temporary accommodation somewhere. Once the council reached that final duty, wouldn't it kind of kick back in again and they'd be able to get back on it? Is that how it might work?
No, I don't know. It depends. If the council accepted a Section 193 duty, but they were still in temporary accommodation outside the borough, I think they would remain ineligible to rejoin the housing, go back on the housing register.
Wow. And okay, and so would essentially the council look to discharge the duty into private rented accommodation in Timbuktu or whatever? Yeah. Wow, that's harsh.
It is, but the background to that is that there was many years of local authorities struggling with the problem of the fact that the only way for many years that you could get social housing was by applying as homeless, because then you would get loads of points and then priority for housing register purposes. And then there was the sort of notional non-homeless applicant who was sort of living at home and waiting to get a chance, who would just be jumped over the lid. And I'm not saying that I think that what I've described is anything other than outrageous, but it led to a lot of councils drawing up very dodgy things in their allocation policy, that if you've been convicted of something involving antisocial behaviour, you're banned. Or then I never feel comfortable with all this stuff about if you've been in the armed forces, you get sort of priority, which all sounds a bit sort of wrong to me. So there's some really odd things in housing registers and allocation policies, but I think one of them is that you can actually bar people. And I had problems with Kingston's allocation policy as well, which said you had to have been there for, I think that was actually not so bad. It had to be 3 out of the last 5 years or something. So if you were out temporarily, you could go back in. But that's my comment there.
Yeah, I mean, once there's nothing surprises me in London. I said this last week, I think. If you're not in London, like, it's not as bad as all the, you kind of hear a lot of horror stories. It is much better, as I say, even in Bedford, which isn't that far away. A lot of people have a great time in the process, but it's not disastrous. Like, they're not in temporary accommodation for too long. I say that, a year or two, maybe 2 years, but generally it's decent quality temporary accommodation. And I've seen lots of cases where people, do get moved more quickly. That and ultimately the ultimate, and the kind of end point for them is actually half decent or actually fully decent, long-term accommodation at the end of it. So it's I guess the nature of our work means we see where it doesn't go well. We see where it goes wrong, basically. Yeah. But I think lots of people do kind of have a good experience of it. And I don't want to kind of make out
even in London it happens.
Terrible. Yeah,
people do get housed in social housing in fair situations. I've got one parting thought, if I may. I have to stop now, but before I wanted to get it in before the end. It goes back to that what to expect from assessment meetings. And one piece of advice I would give people is don't take it personally, because a very common question I get asked is, what did I do to them? Why are they being so horrible to me? I did my best to be nice, but they were just so rude and aggressive. And I always say, well, don't take it personally. It's not you. I'm not saying everyone gets treated like that, but it's just, again, the system, it just gravitates towards the housing officers just get ground down and can sometimes seem very negative. But it isn't, it's nothing to do with you personally. Well, 90% of the time.
Yeah, no, it's just cool. And just the final quick question we'll answer is again just from Omar. Just can I ask for a telephone assessment instead of a face-to-face and the same gender officer? So because you're going to get a very cynical answer from me here. Yes, you can absolutely ask that. In my experience, sometimes if you go in saying, "Can I have this?" Can I be housed in this area? You can guarantee that one thing you won't be is housed in the area you've asked for. So again, if you said, "Can I have a telephone just a telephone assessment without giving any reason for it, they might think you're dodging. That they'll say, no, you definitely need a face-to-face. We need to check you out. So, and again, if you say, well, can I have a female officer if you're a female, they won't say, well, no, we're going to give you a male one, just because it's kind of almost the opposite of what you ask. I know that sounds horrendously cynical, but I've worked in teams where that's kind of how it works. As I say, you kind of almost don't want to go in saying what you actually want, because that's, as I say, they'll kind of they'll make it as unappealing as possible.
Can I add?
Again,
Oh, sorry, Shannon.
no, it just, if they are, because I think they were the person that mentioned about PIP. If you're, say, on PIP and you need to have a telephone assessment because it's to do with reasonable adjustments and stuff like that, you're almost best to take a picture of that and attach it to your email and be like, look, I'm really sorry. I know this isn't the way things are normally done. I'm not trying to be difficult. Is there any way we could have a telephone appointment? And then, because you're completely right, Mike, in what you're saying, I think if you can then almost be extra flexible about when you can answer the phone, make sure you answer it on the first ring, and just be sort of, extra handy getting all the documents together, then that can sort of help with that friction that might arise.
Yeah, cool. Okay, well, I think we've answered all the questions that have been put in there live, as well as a few others. So hopefully, guys, this has been helpful. As I said, we're going to try and do this every Thursday if we can get around to it. Shannon and I deliver training on this. If you're a professional watching this, we deliver online training and in-person training these days as well. So do check us out on Eventbrite if you want to have a look at what we kind of cover. But yeah, and something I haven't mentioned yet. So there is a really good Facebook group, which I've got nothing to do with. I'm in the group, but I don't run it or anything, called Housing Advice Independent. So that is another good resource if you kind of want to get a response to a particular question. I'm not saying it's always perfect for advice, neither is ours really, but it's something that you can kind of maybe get some stuff there. So yeah, let's leave it there. Say hopefully next week, same time. Thanks, Will and Shannon, for your time tonight. And yeah, we with the relief duty stuff, I need to go and read that chapter again by the sound of it, just to kind of get my head around it properly. But yeah, cool. All right, see you later, guys. Take care.